Good morning and welcome to the 10th meeting of the Social Justice and Social Security Committee for 2025, and we have no apologies this morning. So today is the second day of the committee's consideration of the House and Scotland Bill at Stage 2. I welcome Paul McLennan, Minister for Housing, and his officials to the meeting. And I remind the Scottish Government officials that they are here to assist the Minister during the Stage 2 debate. They are not permitted to participate in the debate. For this reason, members should not direct any questions to them. We will also be joined throughout the meeting by other MSPs who will be speaking to their amendments. Members should have with them a copy of the bill, the marshalled list and the groupings. These documents are available on the bill page on the Scottish Parliament's website for anyone observing. I will not explain for a second time the procedure we will be following during our Stage 2 consideration, you'll be pleased to know, of the amendments. However, I would like to remind members that interventions should be brief. It is up to the member speaking to an amendment whether to accept an intervention. I will now begin our consideration of the amendments. So I call Amendment 1057 in the name of Mark Griffin, grouped with amendments as shown in the groupings. Mark Griffin to move Amendment 1057 and speak to all amendments in the group. Thank you.
Thanks, Convener. I move Amendment 1057 in my name and support all of the amendments contained within this group. My amendments in this group are 1057 and 1090, and they set to include an overall set of principles for the duties in Part 5 to prevent homelessness that relevant bodies will be able to work under. I feel adding clarity. The Amendment 1057 is essentially trying to seek clarity and probably more reassurance from the government that there's a clear endpoint for the application of the prevention duties when it comes to a person, and so that they are not trapped in almost a prevention process without getting to the point where they are declared as homeless and so left in limbo, so to speak, but seeking reassurance from the government on that. On 1057, that amendment ensures that when a local authority has taken all of the relevant steps to remove a threat of homelessness and that the applicant still doesn't have stable accommodation, then the applicant should be considered as homeless. It creates a power for limiting the time that these steps are taken without a successful outcome, so that the applicant is not trapped in that situation. If after reasonable attempts the steps taken by the local authority under Section 32 fail to secure accommodation, then I think that there needs to be a clear point at which it is then decided that homelessness can't be prevented through the duty. And like I say, I'm just looking for clarity and reassurance from the government that they feel that this situation can't arise, and there are clear points from someone to go to being treated under the prevention duty to being treated as a homeless applicant. On Amendment 1090, I do have a concern that the bill lacks a level of detail on how the prevention duty will work in practice, and I think there is cross-party, cross-sector support, really strong support for the duty. There are still questions out there about the clarity of how that prevention duty will work in practice. I'm attempting to introduce a set of principles to the bill to go towards alleviating some of those concerns, and we've seen previous examples with the National Care Service Bill, the Social Security Scotland Act, where a set of principles have been introduced within those pieces of legislation. The principles that I've sought to introduce to underpin the prevention duty could be homeless prevention as a shared responsibility, requiring actions to be taken by all relevant bodies. Relevant staff of named bodies would be provided with necessary training to ensure a person-centred approach to homeless prevention. Named bodies working together towards shared outcomes for households that are at risk of homelessness or homeless, and relevant bodies to be held to account to ensure that all opportunities for homelessness prevention are explored, and look forward to hearing the Government's response to those two amendments. Thanks, Commissioner.
Okay, thank you, Mr Griffin. I'm now going to ask the Minister to speak to Amendment 1036 and other amendments in the group. Thank you.
Thank you, Convener. I'd like to begin my remarks by making clear that the Scottish Government have listened to stakeholders and members of this committee at stage 1 on the need to bring more clarity to the operation of the new duties, and in particular Ask and Act. We have heard calls for more detail to be included in regulations and of the importance of guidance, and we will work closely with stakeholders and members of this committee on ensuring the content of both is fit for purpose. Firstly, I want to recognise why there is concern if prevention interventions are not successful, a person should be considered homeless and action taken. Amendment 1057 looks to amend Section 32 of the 1987 Act to provide that where the steps are under subsection 2ZA, that's to secure or continuing alternative accommodation, don't provide accommodation, the individual with accommodation after a prescribed period, the individual is automatically classed as homeless. A fixed timescale would have to be set by Scottish Ministers via regulations, after which point every individual who is threatened with homelessness would be automatically classed by homelessness. This is already provided for within current legislation. There is no need for further application to be made if an individual, if they become homeless, having previously been threatened with homelessness. There is no way to provide one set of time after which every individual who is threatened with homelessness should be treated as homeless. Each case with turn on its own individual circumstances. But I am happy to engage further with Mr Griffin if he continues to have concerns on that particular issue. Local authorities need to act to ensure accommodation remains available as part of their duty to prevent homelessness. And if circumstances change in that regard, a homelessness assessment should be made. There is no need for an individual who is threatened with homelessness and has applied for homelessness assistance to make a further application for homeless assistance once they become homelessness. Amendment 1036, in my name, is a minor technical change to clarify the duties of a legal authority under sections 32(2)(c) of the Housing Scotland Act 1987. Amendments 1092 and 1093 seek to ensure that a person threatened with homelessness is informed about advice and assistance to be provided under Section 32 of the Housing Scotland Act 1987. I'm sympathetic to Maggie Chapman's intention behind these amendments, but they're unnecessary as the Scottish Ministers already have the power to prescribe the types of advice and assistance that must be provided by the local authority, again in Section 32(2)(c) of the 1987 Act, as inserted by the Bill, and to produce guidance for local authorities in Section 37 of the 1987 Act. The new powers conferred by my amendments 1042 and 1044 may also be used to require local authorities and other relevant bodies to take additional action in relation to these matters. Amendments 102 and 1093 would create a confusing regulatory landscape alongside these existing powers. So I would urge Ms Chapman not to press these amendments. We have also heard from stakeholders of their concerns that the right to review decisions by local authorities in relation to persons threatened with homelessness was not clear enough and need to be extended to cover the new Ask and Act duties. So we have taken action through Amendment 1040 to clarify and extend that important right. We will work with the relevant bodies to ensure the right to review works as intended through the provision of guidance. More broadly, we have listened to stakeholders such as Crisis and others and have considered the recommendations of the Committee Stage 1 report, asking us to provide more detail in legislation about the operation of Ask and Act. Amendment 1094 in the name of Maggie Chapman also seeks to expand the right which I have addressed through my amendment 1040. 1094 would also duplicate what my amendment 1040 already does. I'm going to ask Ms Chapman not to press it. My amendments 1042 and 1044 confer regulation making powers to specify additional action to be taken by relevant bodies in relation to any person who is threatened with homelessness, including any action to be taken in relation to the assessment process and the provision of information. This will be an important and flexible way to achieve the level of detail we have been asked to provide with regulations developed in consultation with stakeholders. Amendment 1095 in the name of Maggie Chapman is not therefore necessary. Amendments 1042 and 1044 lodged by myself already have a power for ministers to specify additional action relevant bodies may take, and this power is clarified in Amendment 1044. All of these issues which Amendment 1095 attempts to address can be addressed by the powers created by the Amendments 1042 and 1044. Amendment 1018 in the name of Mr Balfour seeks to do something similar to my amendment, but it creates a risk of narrowing the duties that a relevant body must take. The regulation power in my amendments would enable the Scottish Ministers to specify additional action that a relevant body must take over and above their general duty to take such action as they consider appropriate. Mr Balfour's amendment also refers to a potential appeal to the First Tier Tribunal, but no such appeal rights exist at present. The right to review is considered sufficient here, and I should add that the right to review was a key issue for Crisis during our engagement with them on potential amendments. Amendment 1010 in the name of Mr Stewart seeks to create a right to review the actions of every relevant body under the Ask and Act duties. Again, my Amendment 104 simply seeks to extend an existing right to review the decisions of a local authority. Mr Stewart's amendment would therefore require new review processes to be created by relevant bodies. I believe this would need further consultation with the relevant bodies. Such a right to be considered necessary, the powers to prescribe additional action that a relevant body must take would enable this to be introduced via regulations. Amendment 10. Yeah.
In relation to 1010 and submitted by my colleague Mr Alexander Stewart, will the Minister be willing to work with Mr Stewart directly on this amendment, because you did say that your amendment stretches to local authorities, but of course if we want Ask and Act to work efficiently, surely that has to extend into other public bodies too. I briefly discussed that with Mr Stewart and said I was continued happy to engage with him on that point. So coming back to Amendment 1090 in the name of Mark Griffin, this proposes to create a duty on the Scottish Minister to set out principles which would apply to the Ask and Act duties. I appreciate the intention behind this amendment, but I am clear that there are very clear principles in the bill in relation to homeless prevention. Firstly, that relevant bodies must take appropriate action to remove and minimise the threat of homelessness, and secondly, this action must be taken when a body is informed or has reason to believe that a person may be homeless or threatened with homelessness. This makes clear that the prevention of homelessness is everybody's business, and that those threatened with homelessness should get help earlier. I am concerned that this amendment would place a duty on the Scottish Ministers which they cannot guarantee compliance with. Regulations subject to the affirmative procedure are not within the gift of the Scottish Ministers. They are at the discretion of Parliament. I also note that some of the principles listed in the amendment paraphrase duties that are already placed on relevant bodies, such as that which states relevant bodies must work together. A statement of principles could be set out in guidance under Section 36D of the 1987 Act, and guiding principles are clearly more suited to guidance than subordinate legislation. I would ask members to support my amendments 1036, 1040, 1042 and 1044, and would urge Mr Griffin, Ms Chapman, Mr Balfour and Mr Stewart not to press amendments in this group, and if pressed I would ask members not to support them. Thank you, Convener.
Okay, thank you, Minister. I'm going to invite Maggie Chapman to speak to Amendment 1092 and other amendments in the group. Thank you.
Good morning, Convener. Good morning, Committee and Minister. Thank you for the opportunity to speak this morning. Like Mark Griffin, I'm supportive of all the amendments in this group. And with regards to my amendment specifically, I've worked with Crisis to bring these forward to improve the bill's provision on homelessness prevention. Amendment 1092 and the consequential 1093 creates a requirement for the local authority to provide the applicant with information on the advice and assistance they are providing to assist them and on the outcome that is being sought. This is so that the applicant and anyone supporting them knows what should be being done, and it's absolutely central in making sure the process is person-centred and for transparency. It's been quite clear, both in the stage one evidence gathering, but also in general working of the system, that applicants aren't always aware of what actions are being taken, or they think things are happening and things are not. So that this places that explicit duty to ensure that applicants are aware of what's going on. And the Scottish Government's own Homelessness Prevention Review Group was clear that they envisaged a transparent, person-centred process with the applicant's voice at the heart of discussions around support. And these amendments moves us towards that, along with other amendments in the group by other MSPs. And I just note that the Welsh Government is moving towards a similar system. Moving to 1094, this amendment seeks to ensure that there's a right to review the effectiveness and appropriateness of assistance provided to someone threatened with homelessness, and specifically whether it has fulfilled the intention of removing or minimising the threat of homelessness. Crisis believes that the existing statutory right to review must be expanded to address the needs and support people that are offered to prevent their homelessness. This is an essential accountability tool for individuals who are at risk of homelessness. As well as having support from Crisis, this closely mirrors recommendations from the Homelessness Prevention Review Group. 1095 creates a provision for further definition of what relevant bodies are required to do in order to ensure that all relevant bodies and local authorities are subject to duties of equal legal strength when addressing the threat of homelessness. And it's also to ensure that Act duties do not simply result in referrals to the local authority or to some other body. A duty to act cannot simply become a duty to refer. This may include what the specified actions are and how they assess responsibilities. Regulations should specify actions for each relevant body. As yet, these details haven't been developed, so it could be tested through piloting and consultation with the relevant bodies before being set out in regulations. And I think there have been ongoing discussions about this with stakeholders about what those pilots could look like and what they could achieve. 1095 also creates a means for individual accountability on relevant bodies, subject to the Act duties of the Act duties in 36C of the bill, where relevant bodies do not fulfil their duties or there is a dispute over the facts or decisions made. I note again that these are all amendments that have been worked up in consultation and with Crisis, who have been close partners of the Scottish Government in tackling homelessness and have exceptional knowledge of how our homelessness system is and is not working. And I acknowledge the comments that the Minister has made about some of these powers already existing, but I think the fact that Crisis has been trying to get more clarity and more definition here, it's important for us to have these conversations and to at least consider how we can improve both assessments and reviews in this section, because we know that not everything is working as it should. Thank you.
Okay, thank you, Ms Chapman. I'm now going to invite Jeremy Balfour to speak to Amendment 1018 and other amendments in the group. Thank you.
Thank you, Convener, and good morning, Minister and colleagues. I think as we go through these amendments within this grouping, but also within other groupings this morning, I suspect we're going to see some of the weaknesses that are within this bill. Everyone, I'm sure, within this Parliament wants to see this bill work, but as it is constituted at the moment, there are simply too many unanswered questions and too many uncertainties in regard to that. I think when Mr Griffin was talking to his Amendment 1090, he said there was a lack of clarity in regard to Ask and Act and the duties behind that. I think he was being kind in regard to that, because I think there was a gaping hole in regard to what does this mean in practice if this comes into play. The example I give Convener and I've given to others is if I am a nurse up at the Royal on a Saturday night at 2 AM and somebody comes in who either discloses or becomes clear that they are homeless, what does that nurse do? What is her duty around that? And there is really no clarity in regard to that. And I think we are setting public bodies up to fail unless we can be very clear in our definition and there's a very clear understanding. Mr Stewart, when he was on the committee, I think on one occasion when we were taking evidence, quite forcefully pointed out that there needs to be a change of culture if anything is going to work around Ask and Act. And that is true, there does need to be a change of culture, but there can only be a change of culture if people understand what that cultural change is meant to look like in practice. And at the moment, this bill simply doesn't have that. In regard to Mr McLennan's 1040, again, one of the problems with this bill is that we're putting a lot of weight on guidance. Now, as the Minister will understand, guidance has no legal authority. There is nowhere to enforce that. Guidance can be a piece of paper that comes out but gives neither the public body or the person who may be threatened with homelessness any rights or any legal challenge to it. And that's why my view is we will support 1040, but in my view, this should be done by amendment, not by guidance. If I could move to the amendment in my name, I suppose we are hoping, expecting that public bodies will have this cultural change and that everyone will simply understand the duty of Ask and Act on them. But this bill gives no real stick to if a public body doesn't do this. Again, there's a lack of clarity in regard to this, that what happens if NHS Tayside or NHS Lothian, or what happens if any other public body that we end up with doesn't do this. There's absolutely really no stick to hit them with. And that's what my 1018 allows. It allows somebody who has not been treated correctly to have at least the option of challenging the decisions made by that public body. And that seems to me a very legitimate right. Now, I appreciate that you can already do judicial review in regard to decisions of public bodies, but this puts it on the face of the bill. And thus, it doesn't create a new right, doesn't create something that is not there in law already, but I think it gives a real indication from this Parliament that we expect public bodies to take Ask and Act absolutely seriously, and if they don't, they could be open to legal challenge. And that seems to me a place that we would want to get to. And I will leave it there, Convener. Thank you.
Okay, thank you, Mr Balfour. I'm now going to invite Megan Gallagher to speak to 10.2 on behalf of Alexander Stewart and other amendments in the group. Thank you.
Thank you very much, Convener. And on Amendment 1010, this amendment inserts a new section into the 1987 Act alongside new sections 36A to 36D. This will ensure that a person identifying as homeless has the right to request a review to the various stages of support they receive if they feel let down or have not been recognised as homeless. And I think this relates to comments that have been made by other members this morning in relation to making sure that the definition of Ask and Act is tightened to make sure that all relevant bodies who are going to be undertaking these particular Ask and Act duties know exactly what it is that's expected of them, but everyone can receive a level of service that they would believe that they should receive should they be presenting in such a way. And that's certainly where my concerns lie with this particular section of the bill. I'm not convinced the bill as it stands, and I know the Minister has, of course, submitted amendments this morning which the Conservatives are supportive of, but I still think that there is further work to be done, particularly in relation to making sure that public bodies have the confidence to ask and act, but also to make sure, as Jeremy Balfour rightly pointed out, that no legal challenges can happen on the back of this legislation. I think that's something that we've all got to be incredibly mindful of in relation to the ask and act duty, because again, you know, when you're requesting the right to review, which I do believe should be contained within the bill. If someone wants to make that review to see what level of service that they should receive, benchmarking that against the service that they did receive, I think that's got to be made clear within the bill in terms of what happens through that process, and indeed what happens to a person should they follow down that route. So I do believe with the bill that we've got more tightening to do. I'm happy to work with the Minister and my colleague Alexander Stewart regarding Amendment 1010. But again, when we're looking at Asking Act, I think Jeremy Balfour hit the nail on the head in terms of the weaknesses of the bill is now being laid bare this morning at committee. Thank you.
Okay, thank you, Ms Gallagher. I'm now going to invite any other members if they want to comment. Okay. So I'm going to ask Mark Griffin to wind up, press or withdraw Amendment 1057.
Thanks, Convener. On Amendment 1057, I'm reassured by what the Minister has to say regarding how 1057 would work and the existing legislation that Government feel it already covers. I do think, though, that we still need to pay close attention to the operation of this bill if it becomes an act, and guard against the potential for someone to be held in a point of limbo between prevention and actual homelessness, and the different duties that would apply to that person from a local authority. So I think it is one worth keeping an eye on. On Amendment 1090, I've taken on board what the Minister has said, but the Minister will be aware that there is strong support for the principle of Ask and Act and the prevention, but there is a clear desire for much more detail as to how that would operate, would operate for the individual, the rights they would have, the rights that they would be able to pursue if they felt that Ask and Act hadn't been upheld by a particular public body. But more crucially, I think the training and the knowledge and the expectations that would apply to the public bodies who were exercising this, I think there is clearly a desire for much greater clarity. So I don't plan to press 1090 to a vote today, but I think I would hope for further discussion amongst stakeholders in the government, and happy to be involved in any of those discussions to provide greater clarity on what Ask and Act specifically means. But I'll close there, Convener, and seek permission to withdraw Amendment 1057.
Okay, thank you, Mr Griffin. Does any member object to the amendment being withdrawn? Okay, thank you. That amendment is withdrawn. 1057 is withdrawn. Next item is 1035. So I call Amendment 1035 in the name of Kevin Stewart, already debated with Amendment 1052. Kevin Stewart, to move or not move?
Moved, please, Convener.
Okay. The question is that Amendment 1035 be agreed to. Are we all agreed? No. We're not agreed. So there will be a division. And for those in favour of Amendment 1035, could you please raise your hands now? Thank you. Just checking that Alice got everybody. Yeah, okay. For those against Amendment 1035, could you put your hands up, please? For those who wish to abstain from Amendment 1035, could you please raise your hands? So I can confirm that it's 6 for Amendment 1035, and it's recorded 2 abstentions for Amendment 1035. Therefore, Amendment 1035 is agreed. Thank you. I call Amendment 1036 in the name of the Minister, already debated with Amendment 1057. Minister to move formally. Okay. The question is that Amendment 1036 be agreed to. Are we all agreed? The amendment is therefore agreed. I call Amendment 1058 in the name, I believe it's Mark Griffin, on behalf of Pam Duncan Glancy, already debated with Amendment 1015. So I'm asking Mark Griffin on behalf of Pam Duncan Glancy to move or not move.
Not moved.
Okay. Thank you. I call Amendment 1037 in the name of Kevin Stewart, already debated with Amendment 1052. Kevin Stewart to move or not move.
Moved, convener.
Okay. The question is that Amendment 1037 be agreed to. Are we all agreed? No. Or not agreed? So there will be a division. So can I ask for those actually in favour of Amendment 1037 to raise their hands now? Okay. Can I ask for those who are against Amendment 1037 to raise their hands now? And can I ask for those wishing to abstain against Amendment 1037 to raise their hands now? Okay, in terms of Amendment 1037, we have 6 for and 2 abstentions. Therefore, Amendment 1037 is agreed. Thank you. I now call Amendment 1092 in the name of Maggie Chapman, already debated with Amendment 1057. Maggie Chapman to move or not move? Not moved. Okay. Call Amendment 1038 in the name of Kevin Stewart, already debated with Amendment 1052. Kevin Stewart to move or not move?
Moved, convener.
Okay. The question is that Amendment 1038 be agreed to. Are we all agreed? Yeah. We're not agreed. So there will be a division. So can I ask those in favour of Amendment 1038 to please raise their hands now? Can I ask for those who are against Amendment 1038 to raise their hands? And can I ask for those wishing to abstain against Amendment 1038 to please raise their hands now? Okay, so Amendment 1038, we have 6 for and 2 abstentions. Therefore, Amendment 1038 is agreed. Thank you. I call Amendment 1039 in the name of Kevin Stewart, already debated with Amendment 1052. Kevin Stewart to move or not move?
Moved, please, convener.
Okay. The question is that Amendment 1039 be agreed to. Are we all agreed? Yeah. No. We're not agreed. Therefore, there will be a division. So can I ask those in favour of Amendment 1039 to please raise their hands now? Okay. Can I ask those who are against Amendment 1039 to raise their hands now? And can I ask those wishing to abstain from Amendment 1039 to please raise their hands? Okay, we have 6 for and 2 recorded abstentions. Therefore, Amendment 1039 is agreed. Thank you. I call Amendment 1093 in the name of Maggie Chapman, already debated with Amendment 1057. Maggie Chapman to move or not move?
Not moved.
Okay. I call Amendment 1059 in the name of Mark Griffin, already debated with Amendment 1078. Mark Griffin to move or not move?
Not moved.
Okay. I call Amendment 1060 in the name of Pam Duncan-Glancy, already debated with Amendment 1015, and I'll ask Mark Griffin on behalf of Pam Duncan-Glancy to move or not move.
Not moved.
I call Amendment 1040 in the name of the Minister, already debated with Amendment 1057. Minister to move formally.
Moved formally.
Okay. The question is that Amendment 1040 be agreed to. Are we all agreed?
Yes.
We're all agreed. Therefore, Amendment 1040 is agreed. I call Amendment 1094 in the name of Maggie Chapman, already debated with Amendment 1057. Maggie Chapman to move or not move?
Not moved.
Okay. I call Amendment 1061 in the name of Katie Clark, grouped with amendments as shown in the groupings. Katie Clark to move Amendment 1061 and speak to all amendments in the group. Thank you.
Thank you, Convener, for the opportunity to speak to my amendments in this group, which are probing amendments put down after discussions with Scottish Women's Aid and aimed at strengthening the requirement at Section 56A of the Bill for social housing providers to take account of a domestic abuse policy, for the review of women's refuge provision and to enable the public debt of domestic abuse survivors, for example, rent arrears, to be written off. The Minister was kind enough to meet with me last week to discuss my amendments, and I understand that his general approach is that the level of detail outlined in my amendments should be in regulation. This relates to the wider debate about framework bills and enabling legislation and the scrutiny of regulations and guidance, which was referred to by a number of members last week. I would argue that it is important that some of these provisions are in the face of the bill. My amendments relate to the protection of victims of domestic abuse and the housing instability that so often arises in those situations. We need robust, codified support for people who face homelessness as a result of abuse. Amendment 1061 requires relevant bodies to ask individuals who have reason to believe who they may have reason to believe may be homeless or threatened with homelessness, whether their situation arose as a consequence of either past or ongoing experience of abuse. Amendment 1062 defines abuse within a whole and broad understanding of harm or risk of harm for the purposes of duties to ask if a person is homeless or threatened with homelessness, to act if a person may be homeless, and to act if a person may be threatened with homelessness. Abuse is acknowledged as encompassing cases of abusive behaviour from a partner or ex-partner within the meaning of Section 2 of the Domestic Abuse Protection Scotland Act 2021. Amendment 1060 requires that if the relevant body is in fact informed that a person is threatened with homelessness as a consequence of having experienced or experiencing abuse, they must provide the person with details of the support that may be available to that person. Amendment 1064 expands this for individuals who relevant bodies have reason to believe may be threatened with homelessness due to the threatening or abusive behaviour of others. Amendment 1088 calls for Scottish ministers to carry out a review of temporary housing provided by persons who have left their homes because of domestic abuse within 1 year of royal assent. This review must consider whether the temporary housing is compliant with international standards in respect of a number of matters, including provisions under the Council of Europe Convention of Preventing Violence Against Women and Domestic Abuse. The review would consider the availability of specialist provision and the suitability of funding for such housing. Amendment 1088 requires Scottish ministers to consult organisations providing housing, such as local authorities and other persons that they consider appropriate as part of that review, and asks Scottish ministers to prepare and publish a report of this review, which would set out any action ministers plan to take. Amendment 1089 relates to the issue of public debt and the scope of domestic abuse policies to enable steps to be taken to mitigate, particularly in relation to rent arrears for tenants for whom an application for housing benefit has not yet been determined but is likely to be paid at a level allowing the tenant to satisfy outstanding rent or other financial obligations of tenancy. So this action would include the whole or any part of rent arrears to enable those to be effectively written off in certain circumstances. I will. I'm coming to an end, but I'd be happy to take an intervention.
I'm grateful to remember. I'm just wondering in regard to the word and what you understand by include consideration, because that could mean I thought about it and then move on to the next. You know, what does that act? If I'm a housing officer, if I'm in a local authority, and I'm sitting there on a Tuesday afternoon, what would you expect to include consideration to actually mean in practice?
I would mean in practice that all the circumstances would be taken into account, and obviously the amendment relates to situations where someone is a survivor or experiencing domestic abuse, and it would enable all of the factors to be taken into account, and for the council and in particular the housing officer to make a decision based on the full facts as were presented to them. So it's an enabling piece of legislation, but it requires local authorities to consider all these matters, and I think all of us as representatives will be aware of circumstances where we feel that such action would be appropriate, and that individuals are in a situation where substantial rent arrears have been accrued in circumstances where we would believe, as a matter of public policy, it would be appropriate for those rent arrears to be effectively written off. As I say, it's not my intention to move any of these amendments or to push them to the vote today, but to listen to the government's response before stage 3, and indeed any contributions from other members in terms of the drafting, if there's a view that there needs to be a tightening in terms of the drafting before stage 3. I will.
Thanks for taking the intervention. It's just on 1088. I just want to have some further clarity on the phrase international standards, because if we're to have a review of whether such housing is compliant, I'm going by the wording in the amendment, with international standards, then standards across the world will vary. I mean, there'll be different standards in every country. So I'm not quite clear how we can achieve. I'm not sure what the member wants to achieve. I accept she's not going to press the amendment, but do you see the problem here?
The international standards are, if you like, obligations that are set out under international treaties such as the Istanbul Treaty. So these would be the international standards. Whether the UK has signed up officially or not, the reference would be made to the kind of standards and obligations that are being presented at an international level, and it would be a review to see to what extent Scotland complies with those higher standards, if you like, rather than the lower standards that may exist in some countries, but if you like, the work that has been done to set out criteria and guidelines in terms of how domestic abuse and women should be treated in these types of situations. So that's very much the thinking behind the amendment. As I say, I'm happy to reflect and to consider any representations in terms of a tighter definition. It obviously was an amendment that was drafted by the clerks in this House, in this Parliament, and therefore, obviously, I'm happy to reflect in terms of the drafting, but the intention would be very much that it would be, the Council of Europe Convention in particular, but any other international standards that have been worked on and debated and agreed as appropriate in terms of the kinds of standards that states should be addressing. So I look forward to the Minister's contribution.
Okay, thank you, Ms Clark. I'm now going to invite Maggie Chapman to speak to Amendment 1022 and other amendments in the group. Thank you.
Thanks very much, Convener, and I'm grateful to Katie Clark for raising the issues that she has in her amendments in this group. I think there are opportunities for us to make much clearer what is and what isn't covered and what is and what shouldn't be on the face of this bill. But turning to my amendment 1022, Scottish Women's Aid has drawn attention to the importance of widening the definition of domestic violence in this bill. The amendment that I've worked on with them with Scottish Women's Aid expands the definition to cover coercive control and other aspects of violence. It would ensure that we recognise that domestic violence can cover a very broad range of actions, and abusers can be anyone in the household, not just a partner or ex-partner. We know, for example, that young trans people have a disproportionately high risk of homelessness and can be at risk from controlling or coercive family members, not necessarily a partner. We also know that people might be at risk of homelessness because of honour-based violence. Again, not something that would have to be perpetrated by someone's partner or ex-partner. Neither of these specific examples, nor other examples of abuse and violence perpetrated by someone who is not a partner or ex-partner, would be covered under the bill's current definition, but would if my amendment 1022 was accepted. The wider the definition, the more we can identify domestic abuse and other forms of violence in our homelessness systems, and the better we can help victims and survivors. I would urge committee members to recognise that violence happens in a range of ways and is perpetrated by a range of people. You are not only at risk of violence from your partner. It could be a parent, it could be a child. The bill does not currently cover those examples, and I would ask the committee to support this amendment. Thank you. Turning to 1069, I've also worked on this with Scottish Women's Aid. The working group report referred to in the amendment made a wide range of recommendations, and these were accepted by the Scottish Government. I'm pleased to see some of them in the bill introduced by my Green colleague Patrick Harvey, and in both Scottish Government amendments and those from other colleagues too. But there was a very wide-ranging report with some 27 recommendations, and we still have some way to go to ensure that all of the recommendations are implemented. There is more work to be done, for instance, on housing first strategies for victims and survivors, more on ensuring homelessness policies are designed and implemented with a gendered lens, more done to improve how homelessness due to domestic abuse appears in statistics. I'm therefore recommending a simple monitoring process in the bill whereby we check up annually on progress on these recommendations as already agreed by the Scottish Government but not implemented anywhere in the bill as it currently stands. Thank you, Convener.
Okay, thank you, Ms Chapman. I'm now going to invite Jeremy Balfour to speak to Amendment 1023 and other amendments in the group. Thank you.
Thank you again, Convener. Clearly, we are turning to a really important part of the bill, and again, I'm sure all members want to see this actually work again in practice. I appreciate Katie Clark isn't going to be moving her amendments today. We would have been supporting them. I think the intention behind them is right. I suppose, as I just made in my intervention, what we mean in regard to consideration, I think if you were to bring that back, I don't want to teach my granny to suck eggs as a better lawyer than I ever was, but I do think there needs to be a better legal test in regard to that, because my fear is it simply becomes a tick box exercise done by people in regard to that. In regard to the two amendments brought by Maggie Chapman, we would be supporting these if she decides to move them later on this morning, and we are supporting the amendments which will be discussed later by Megan Gallagher and by Rachel Hamilton. If I can turn to my own amendment in regard to 1023, this creates a duty on social landlords to point those who have experienced domestic abuse to the appropriate legal advice and opportunities they can get. I claim no expertise in regard to what it must be to experience domestic abuse, but I am sure that people do need to have the appropriate legal help and advice at a point where they need it. It is not often clear where to get that legal advice. It's not clear which legal firms do that type of work anymore, wherever you are, and particularly in rural areas of Scotland, there is a lack of either criminal or civil lawyers who do legal aid work around domestic abuse. This is not making the social landlord do the work, but it is pointing the individual to that. And I think that would be a really helpful approach, Mr Dodds.
I appreciate Mr Balfour for giving me. I'm listening very carefully. I suppose it's a question about what's not in your amendment, and I'm not sure how I feel about the amendment, to be honest with you, but I'm listening carefully. A lot of survivors of domestic abuse will be at threat of losing their homes from the private rented sector as well. I'm just wondering, and I get there's occasional landlords out there who are registered with 1 or 2 properties and they're not at scale, but there's a lot of large, almost industrial landlords out there as well, and letting agencies. I'm just wondering whether you feel there should be requirements on private landlords and letting agencies also.
Can I come back to that point, because I want to deal with it in another amendment which I think covers exactly the same point. So I will deal with it, and I think it's a fair point. If I can then move on to amendments 1024 to 130, I should say I won't be moving these this morning, but I would be interested to hear a bit more in regard to where the Scottish Government is in regard to that. The first amendments put the duty which is there for social landlords onto those who are private landlords as well. And I think this, if I pick up Mr Dawes' point, where I think my amendment, having reflected on it and had helpful conversations with the Minister, that if you own 1 or 2 flats, that duty probably is an overburdensome duty and one that shouldn't be followed. But if, as Mr Dawes has pointed out, you own multiple flats, then perhaps that duty should apply both for Amendment 1023, but also in regard to 1024. And so I would be interested to know if the Government would look at this amendment in a different light if we put on a number of flats that this would apply to, rather than having it picking up just 1 or 2 individuals. My rest of my amendments in some ways follow similar to that of Katie Clark's one, in regard to it is putting a duty on social landlords to think about whether they should follow on with evicting somebody simply because they are in arrears. Now, arrears are important. Every social landlord has to keep the revenue coming in to make the cash flow work. But what I am looking at, and again be interested to hear from the Minister, is whether there can be a longer period of grace in regard to that for a social landlord, and whether that could be something we could explore at stage 3. Clearly, all of us want to help protect those who have experienced domestic abuse from being evicted. It makes little sense for someone to be evicted from a property to then become homeless and have to start the journey all over again. As we're aware, often children are connected to this. They then have to move school, they lose their friends, they lose that support network. So I think we all want to see as greater protection on somebody being able to stay in the tenancy if at all possible, but also recognising that there does have to be that rent coming through for social landlords and private landlords so that they can continue to maintain and exist. So I'd be interested to hear what the Minister has to say on the rest of these amendments. Thank you, Convener.
Okay, thank you, Mr Balfour. We're going to take a comfort break just now and come back shortly. Thank you. I'd like to conclude this meeting in light of the news that we have received of the passing of our lovely colleague, Christina McKelvey. And on that note, I would like to note 1 minute's silence as of now. Thank you. Okay. I now suspend the meeting. Thank you.